Huh? All right. Hey, that means you two that are sleeping.
Thank you. You may be seated. Good morning. This is the time set for the 2 a.m. initial appearance calendar on November 19th, 2025. The court's orders for the taking of DNA and fingerprints that was given on the first calendar of this month shall apply to all matters on this calendar. I'll call you each one at a time to the podium. I'll provide a second name to sit in the chair outside of this room. I will let you know what you are here for, if I have appointed an attorney, if you have a bond, and what your release conditions are. And I'm also going to go over the victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. If we could start with Mr. Anaya to the podium and Ms. Joaquin to the chair. May I get your name and date of birth?
Josue Barreras Anaya, December 2nd, 1988.
Thank you, sir. And Ms. Stetson, can I get your appearance for the record?
Yes, Your Honor. Good morning. Ashley Stetson on behalf of the state.
Thank you, Ms. Stetson. We are here today for a new case. It is for one count of murder, a Class 1 felony. Probable cause has been found, and I am going to appoint an attorney to represent you. You're going to have a status conference November 25th at 8:30 and a preliminary hearing December 1st at 8:30. Those are both going to take place in our downtown Superior Courthouse. Next, we are going to discuss your release conditions. Ms. Stetson, did you have a recommendation you'd like to place on the record?
Yes, Your Honor. Very quickly, the allegations of this case are that the suspect flagged down an officer at the Maryvale precinct. He allegedly told the officer that he had shot and killed his girlfriend. The victim of this case was located in the suspect's vehicle. She was wrapped in a blanket or comforter in some sort. The suspect allegedly told law enforcement that there had been a struggle over a firearm. The victim allegedly thought that a firearm that fell from the bed was a cell phone, and the suspect was speaking with other women, Your Honor. This is what the suspect told law enforcement. During that struggle, the firearm went off and the victim was shot. However, Your Honor, the evidence does not support that. When law enforcement was observing and investigating the victim, Your Honor, they did notice that there was a pillow underneath the victim where the bullet was located. The evidence supports the fact that the victim was laying on the pillow, laying down, and that she was shot while her head was on the pillow because the bullet was found in the pillow underneath the victim, Your Honor. That the evidence does not support that there was a struggle over a firearm. The state is requesting bond to be set in the amount of $1 million cash. Your Honor, the state did have a chance to speak with law enforcement from Phoenix Police Department. Law enforcement did indicate that they spoke with the victim's family, and that they stated that there was ongoing history of domestic violence and jealousy issues from the suspect. So, Your Honor, the state does have concerns, obviously, about the safety of the community and the suspect's violent tendencies. So for those reasons, the state is asking for the $1 million cash. The state has outlined its requested conditions of release in the written recommendations, which includes but not limited to electronic monitoring, no contact with the victim's next of kin or family, no returning to the incident location, curfew and house arrest if the suspect is to be released, no possession of any firearms. But that is the reason for the state's recommendation. Thank you, Your Honor.
Thank you, Ms. Stetson. I did review the allegations in this case, sir. I am going to set a secured appearance bond in the amount of $1 million. In the event you were to post that bond and be released from custody, you would be released to the supervision of pretrial services and you would be equipped with electronic monitoring. You would also have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. You may not possess any weapons, and you may not have contact with the alleged victim's next of kin. All of this will be in your paperwork, sir. Did you have any questions?
No, ma'am.
If you will step to your left, the officer will get you that paperwork.
Okay, thank you.
Thank you. And Ms. Stetson, I think the next case you're appearing on is at the end of the calendar.
That is correct. Thank you, Your Honor.
Ms. Joaquin to the podium and Mr. Adams to the chair, please. May I get your name and date of birth?
10/24/73, and it's April Joaquin.
Thank you, ma'am. You are here today on a new case. It is for one count of robbery, a Class 4 felony, one count of possession of a weapon by a prohibited person, a Class 4 felony, and 2 counts of threat, a Class 1 misdemeanor. Probable cause has been found, and I am appointing an attorney to represent you. You will have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30, and you do have a secured appearance bond in the amount of $50,000. In the event you were to post that bond and be released from custody, you'd have written conditions of release. Some of those include not possessing any weapons, not returning to the scene of the alleged crime, and no contact with any alleged victim, complainant, or witness. All of this will be in your paperwork. Did you have any questions?
No, ma'am.
If you'll step to your left, the officer will get you that paperwork.
Okay.
Mr. Adams to the podium and Ms. Hill to the chair.
He's on crutches.
Okay, thank you.
Oh.
May I get your name and date of birth?
Yes, it's Joe Flores Adams, January 25th, 1969.
Thank you, sir. You are here today on a new case.
Yeah,
It is for one count of theft means of transportation, a Class 3 felony, one count of theft, a Class 3 felony, and one count of trafficking stolen property, a Class 3 felony. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. You have a secured appearance bond in the amount of $25,000. In the event you were to post that bond and be released from custody, you would have written conditions of release. You may not return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. All of this will be in your paperwork. Did you have any questions, sir?
yes. What about pretrial services? I was hoping to get out, because I'm on the unlimited income. I get disability. I'm on Social Security disability. I can't afford no type of bond. But I have been living in my address for years. Last time I was placed on the pretrial services and I called, everything was fine, so I wasn't running. I reported. And I have some doctor's appointments I got to do because I got a severe case of polio.
So I'm not going to release you today on pretrial services. I did review the allegations in this case. I do have some concerns for the community. I've also reviewed your criminal history, which does indicate you do have 11 prior felonies and 13 failures to appear. And so based on that, I will not be reducing the bond. You will have to post the bond. If you're unable to do that, you will remain in custody and they will transport you to those hearings. If you'll take a step to your left, the officer will get you that paperwork. Thank you, sir. Ms. Hill to the podium. Mr. Castro to the chair. May I get your name and date of birth?
Christy Cameron Hill, 1/2/1975.
Thank you, ma'am. You are here today on a new case. It is for 2 counts of burglary, a Class 3 felony, 2 counts of criminal trespass, a Class 6 felony, and 2 counts of contributing to the delinquency of a minor, a Class 1 misdemeanor. Probable cause has been found, and I am appointing an attorney to represent you. You will have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. You have a secured appearance bond in the amount of $7,500. In the event you post that bond and are released from custody, you do have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. You may not have contact with any co-defendant, and you may not possess any weapons. All of this will be in your paperwork. Did you have any questions? Please step to your left. The officer will get you that paperwork. Mr. Castro to the podium and Mr. Jeremy Gonzalez to the chair. May I get your name and date of birth?
Hello, my name is Jorge Parada Castro, and 07/21/1998.
Thank you, sir. It does look like you are here on 2 cases. You're here for a new case, as well as a warrant that was issued. Your new charges are for 1 count of aggravated DUI, a Class 4 felony, 1 count of criminal trespass, a Class 6 felony, and 1 count of shoplifting, a Class 1 misdemeanor. For purposes of today's hearing, I am not finding probable cause for criminal trespass, but I am finding probable cause for the aggravated DUI and the shoplifting charge, and I'm appointing an attorney to represent you. You will have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. In this case, you have a secured appearance bond in the amount of $5,000. In the event you post that bond and are released from custody, you will be released to the supervision of pretrial services, and you will have alcohol testing and monitoring. The second case on the calendar is a warrant from the Ironwood Justice Court. It looks like you failed to pay some fines or complete some courses for a criminal damage charge. I'll appoint an attorney and set an arraignment hearing November 24th at 8:30 in the Ironwood Justice Court. In that case, you have a bond of $50. So it's a total bond of $5,050. In the event you do post bond and are released from custody, you have written conditions of release. It will include not possessing or consuming any alcohol and not driving a motor vehicle without a valid driver's license. All of this will be in your paperwork. Did you have any questions?
No, I just wasn't able to make my payments because I just got out of a severe spinal cord injury, so it's kind of been a struggle to make my payments. I was hoping, but that's pretty much it.
Thank you, sir. Please step to your left. The officer will get you that paperwork. Jeremy Gonzalez to the podium, Eric Tenuta to the chair.
Hello,
May I get your name and date of birth?
Jeremy Gonzalez, July 9, 1985.
Thank you, sir. You're here today on a new case. It is for 1 count of burglary, a Class 4 felony, and 1 count of criminal trespass, a Class 6 felony.
Can you repeat that again?
1 count of burglary, a Class 4 felony, and 1 count of criminal trespass, a Class 6 felony.
Okay.
Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. You have a secured appearance bond in the amount of $5,000. In the event you post that bond and are released from custody, you do have written conditions. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or co-defendant. All of this will be in your paperwork. Did you have any questions? Please take a step to your left. The officer will get you that paperwork.
Thank you.
Eric Tenuta to the podium and Samuel Adams to the chair. May I get your name and date of birth?
Eric Tenuta, July 4, 94.
Thank you, sir. You are here today on a new case. It is for 1 count of attempted burglary, a Class 4 felony, and 1 count of attempted criminal damage, a Class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference November 25th at 8:30 and a preliminary hearing December 1st at 8:30. You have a secured appearance bond in the amount of $2,500. In the event you post bond and are released from custody, you have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. All of this will be in your paperwork. Did you have any questions? Please take a step to your left. The officer will get you that paperwork. Samuel Adams to the podium and Matthew Morrison to the chair. May I get your name and date of birth?
Samuel Adams Jr., January 11, 1996.
Thank you, sir. It does look like you are here on a failure to appear bench warrant that was issued for you. It does relate to a pending drug case. I am going to affirm the attorney previously appointed and set a status conference November 25th at 8:30. You have a secured appearance bond in the amount of $2,500. In the event you post that bond and are released from custody, you do have written conditions of release. You may not you may not possess drugs without a valid prescription. You may not drive a motor vehicle without a valid driver's license. And then you'll need to ensure that you attend all of your future hearings. If you were to fail to appear again, another warrant would issue and you'd forfeit any bonds you posted. Did you have any questions, sir?
No, ma'am.
If you'll step to your left, the officer will get you that paperwork.
Thank you.
Matthew Morrison to the podium and Brooke Hoskin to the chair. May I get your name and date of birth?
Matthew Morrison, 12/17/97.
Thank you, sir. You are here today on a probation violation warrant with allegations you violated terms 3 and 5 of your probation. I'm appointing an attorney to represent you and setting a probation revocation hearing November 24th at 8:30. You have a secured appearance bond in the amount of $250. In the event you post that bond and are released from custody, you have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours. All of that will be in your paperwork. Did you have any questions?
No.
Please take a step to your left. The officer will get you that paperwork. Brooke Hoskin to the podium. Dakota to the chair. May I get your name and date of birth?
Brooke Hoskin, 8/17/1995.
Thank you, ma'am. You are here today on a probation violation warrant with allegations you violated terms 6, 7, 12, 15, and 22. I'm appointing an attorney and setting a probation revocation hearing November 24th at 8:30. You do have a secured appearance bond in the amount of $250. In the event you post bond and are released from custody, you do have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. All of that will be in your paperwork, ma'am. Did you have any questions?
Yes. Is it $250, or is there a percentage of that, or is it $250?
It is secured, meaning you can use a bail bonding company, which is typically 10% plus collateral.
Okay.
Anything further, ma'am? Please step to your left. The officer will get you that paperwork. Dakota to the podium. Nathan to the chair. May I get your name and date of birth?
Dakota Wakazu, February 9, 1994.
Thank you, sir. It does look like you've been in custody since November 1st. Is that correct?
Yeah.
And are you currently serving time, or are you being held on a bond?
I'm being held on a bond.
Okay. So what you're here for today is because a direct complaint was filed. It has an offense date of March 29th, 2025, for 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. I'm appointing an attorney and setting a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. You have a secured appearance bond in this case in the amount of $50, so this would be in addition to any other bond you have. If you were to post your bonds and be released from custody, you would have written conditions. That does include not possessing weapons or alcohol and contacting your probation officer within 72 hours of release. All of that will be in your paperwork. Did you have any questions?
Well, no, Your Honor.
Thank you. If you'll step to your left, the officer will get you that paperwork. All right. Nathan to the podium. Julio to the chair. May I get your name and date of birth?
Good morning, ma'am. Nathan Moran, February 17th, 1982.
Thank you, sir. You are here today on a new case. It is for 1 count of criminal trespass of a residential structure, a Class 6 felony.
Yes, ma'am.
Probable cause has been found. However, I am not finding that you are indigent, so you may hire an attorney at your own expense, but I am not appointing an attorney today. You're going to have a status conference December 4th at 8:30, a preliminary hearing December 8th at 8:30. Those are both in the downtown Superior Courthouse.
Yes, ma'am.
I am releasing you to the supervision of pretrial services. You do have written conditions of release. You may not return to the scene of the alleged crime. No contact with any alleged victim, complainant, or witness.
Yes, ma'am.
You're going to get an envelope with your paperwork. You need to read those instructions and contact pretrial services upon your release.
Okay.
Any questions?
No, ma'am.
Please step to your left. The officer will get you
Thank
that
you, ma'am.
paperwork. Thank you, sir. Julio Higueroa to the chair and Jessica Kaywood, Julio to the podium and Jessica to the chair. May I get your name and date of birth?
Will Hagel, 10/14/86.
Thank you, sir. You are here today on a new case for 1 count of dangerous drug possession, a Class 4 felony, and 1 count of criminal trespass, a Class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference December 4th at 8:30 and a preliminary hearing December 8th at 8:30. I'm releasing you to the supervision of pretrial services. You do have written conditions of release. You may not return to the scene of the alleged crime, and no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. You're going to receive an envelope with your paperwork. You need to read those instructions and contact pretrial services upon your release. All of that will be in your paperwork. Did you have any questions?
No, ma'am.
Please step to your left. The officer will get you that paperwork.
Thank you.
Jessica to the podium. Jonathan to the chair. May I get your name and date of birth?
Jessica K. Wood, February 10th, 1977.
Thank you, ma'am. You are here today because a warrant was issued for failing to appear at a hearing for 1 count of driving with a license that was suspended, revoked, or canceled. That has an offense date of April 7th, 2025. Due to the nature of your charges, you are not entitled to court-appointed counsel. I am going to set an arraignment hearing December 3rd at 9 a.m. in the East Mesa Justice Court. I am going to release you today on your own recognizance. That is your promise to appear at that hearing. You do have written conditions of release. You may not possess drugs without a valid prescription, and you may not drive a motor vehicle without a valid driver's license. All of this will be in your paperwork. Did you have any questions?
No, ma'am.
Please step to your left. The officer will get you that paperwork.
Thank you.
Jonathan to the podium. Juan to the chair. May I get your name and date of birth?
Jonathan Charles Swinton, 5/8/95.
Thank you, sir. It does look like you are here on a warrant. You failed to comply or pay some fines for a previous speeding ticket out of the San Marcos Justice Court. Due to the nature of your charges, you are not entitled to court-appointed counsel. You are going to have an arraignment hearing December 9th at 10 a.m. in the San Marcos Justice Court. I am going to release you today on your own recognizance. That is your promise to appear at that hearing. You do have written conditions of release. You may not possess drugs without a valid prescription, and you may not drive a motor vehicle without a valid driver's license. All of that will be listed in your paperwork. Did you have any questions?
No, thank you.
Please step to your left. The officer will get you that paperwork. Juan to the podium. Esteban to the chair. Oh. May I get your name and date of birth?
Juan Castañeda, April 3rd, 1989.
Thank you, sir. You are here today on a new case. It is for 1 count of disorderly conduct and 1 count of assault. Well, 1 count of disorderly conduct, a Class 1 misdemeanor, and 1 count of assault, a Class 3 misdemeanor. Probable cause has been found. Due to the nature of your charges, you're not entitled to court-appointed counsel. You're going to have an arraignment hearing December 9th at 2 p.m. in the Buckeye Municipal Court. I am going to release you today on your own recognizance. That is your promise to appear, but you do have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. If you reside at the same location as the alleged victim, you will have to find an alternative residence. You may contact law enforcement for 1 civil standby to collect any personal belongings. All of that will be in your paperwork. Did you have any questions?
No.
If you'll step to your left, the officer will get you that paperwork.
Thank you.
Thank you. May I get your name and date of birth?
Esteban Luna Campos, 07/11/1997.
Thank you, sir. And do I have the state on the line?
Yes, Your Honor. Ashley Stetson on behalf of the state.
Thank you, Ms. Stetson. We are here today on a new case. It is for 1 count of kidnapping, a Class 2 felony, 1 count of molestation of a child, a Class 2 felony, 1 count of sexual abuse, a Class 3 felony, and 1 count of aggravated assault, a Class 6 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You are going to have a status conference November 25th at 8:30 and a preliminary hearing December 1st at 8:30. Those will both take place in our downtown Superior Courthouse. Next, we are going to discuss your release conditions. Ms. Stetson, did you have a request to put on the record?
Sorry, Your Honor, the state was on mute. Your Honor, the state is requesting bond be set in the amount of $175,000 cash. Your Honor, the allegations are from 2024. The suspect is alleged to have come up behind the minor victim and tackled her or somehow captured her. And in that process, Your Honor, the suspect did touch the victim's breast under her shirt. The state believes the victim is 14 years old. So the state is requesting a bond in the amount of $175,000. The state has great concerns for the safety of the community as well as the safety of minors in the community. The suspect's behavior is concerning, giving the state cause for concern. The state is also requesting standard conditions of release, as well as no contact with any minors, electronic monitoring as required by Arizona statute, no internet use, Your Honor, as well as any other conditions, Your Honor, see this fit. Thank you, Your Honor.
Thank you, Ms. Stetson. I did review the allegations in this case, and I do have some concerns. I am going to set a cash bond in the amount of $50,000. In the event you were to post that bond, you would be released to the supervision of pretrial services, and you'd be equipped with electronic monitoring. You'd also have written conditions of release. You may not return to the scene of the alleged crime, no contact with the alleged victim, complainant, or witness, and you may not have contact with any minors. All of this will be in your paperwork, sir. Did you have any questions?
Yes, so I don't have any numbers, and I told the officers to write them down, which they did. And like I've requested it multiple times throughout the whole process of like trying to retrieve those numbers, which they did write down, and they never gave it to me. Like I don't know any numbers to contact the outside or.
I don't have a solution for you. When you get to processing, you can ask again, but I don't know whether or not they have those numbers available for you. You will be given access to a telephone and phone numbers for bail bonding companies, but if you don't know family or friends' phone numbers, you may not be able to reach them at this time.
Okay.
All right, please step to your left. The officer will get you that paperwork. Ms. Stetson, thank you for appearing here this morning. Feel free to disconnect at your convenience.
Thank you, Your Honor.
The remaining cases will proceed as house calls due to being disruptive, unable to function, or a danger to self. Case number 7 and 15 belong to Tishome Cobbs, date of birth September 12, 1995. He is here today on a new case as well as a probation violation. His new charges are for 1 count of possession of a weapon by a prohibited person, a class 4 felony. Because he is on probation and he was picked up for a new offense while on probation, it is a term 1 violation. I am finding probable cause on both cases, appointing an attorney, setting a probation revocation hearing November 24th at 8:30, a status conference November 25th at 8:30, and a preliminary hearing December 1st at 8:30. He has a secured appearance bond in the amount of $30,000 on his new charges, $5,000 on his probation case, for a total bond of $35,000. In the event he posts bond and is released from custody, he does have written conditions of release. It will include not possessing weapons or alcohol, and he must contact his probation officer within 72 hours. Case number 24, Boyd DeHose, date of birth February 8, 1983, is here on a new case for 1 count of aggravated assault, a class 3 felony, 1 count of threat, a class 1 misdemeanor, and 1 count of assault, a class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent him. He will have a status conference November 25th at 8:30, a preliminary hearing November 1st at 8:30. He does have a secured appearance bond in the amount of $30,000. In the event he posts bond and is released from custody, he does have written conditions of release. He may not return to the scene of the alleged crime, no contact with the alleged victim, complainant, or witness, and he may not possess any weapons. Case number 20 and 21 belong to Larry Taylor, date of birth January 21st, 1981. He is here on a new case as well as a direct complaint. His new charges are for 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, 1 count of tampering with physical evidence, and 1 count of failing to obey police, a Class 2 misdemeanor. For purposes of today only, I am not finding probable cause for the dangerous drugs or drug paraphernalia. I am finding probable cause for the other 2 counts and appointing an attorney. The direct complaint that was filed has an offense date of October 11th, 2025. It is for 1 count of narcotic drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. He is going to have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. He has a $500 bond on his direct complaint, a $50 bond on his new charges, for a total bond of $550. In the event he posts bond and is released from custody, he does have written conditions of release. He may not possess weapons, and he may not possess any drugs without a valid prescription. Case number 6, Chase Elliott, date of birth July 7th, 1994, is here on a warrant. It is for failing to appear at a hearing with an underlying charge of criminal trespass. Due to the nature of his charge, he is not entitled to court-appointed counsel. He's going to have an arraignment hearing December 9th at 8:30 in the West Mesa Justice Court. I am releasing him today on his own recognizance, that is his promise to appear. He does have written conditions of release. He may not possess drugs without a valid prescription. He may not drive a motor vehicle without a valid driver's license. All of this will be included in his paperwork. If anything changes after I meet with any of these parties, I will update the written record. This does conclude our 2 a.m. calendar, and we will now stand in recess until 5 a.m.
All right.
Thank you. You may be seated. Good morning. This is the time set for the 5 a.m. initial appearance calendar on November 19th, 2025. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. I'll call you each one at a time to the podium. I'll provide a second name to sit in the chair outside of this room. I will let you know what you were here for, if I have appointed an attorney, if you have a bond, and what your release conditions are. I'm also going to read over the victim's rights advisement. If you are the victim of a crime with a case pending before the court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. If we could start with Matthew Garland to the podium and Rachel Bernal to the chair.
Matthew. Rachel.
May I get your name and date of birth?
Matthew Joseph Groh, 01/2189.
Thank you, sir. You are here today on a new case. It is for 3 counts of aggravated assault involving a deadly weapon or a dangerous instrument, a Class 3 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You'll have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. You have a secured appearance bond in the amount of $25,000. In the event you post that bond and are released from custody, you have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. All of that will be in your paperwork. Did you have any questions?
Did you say it's $25,000 bond?
Yes, sir.
3 counts of aggravated assault?
Yes, sir.
So I didn't hurt anybody though.
So the allegations are that involve a weapon was used and that you put people in imminent fear. So even though you may not have physically touched them, it would still meet the definition of aggravated assault for purposes of probable cause.
Okay.
All right, if you step to your left, the officer will get you that paperwork.
Okay.
Rachel Bernal to the podium. Jeff to the chair. May I get your name and date of birth?
Yes, please. Rachel Bernal, 6/5/1976.
Thank you, ma'am. You are here on 2 cases. They're both failure to appear bench warrants. The first case relates to a pending drug charge. The other one is a criminal damage charge. I am going to affirm the attorney previously appointed to represent you in these cases and set a status conference November 25th at 8:30. You do have a secured appearance bond of $2,500 in each case for a total bond of $5,000. In the event you were to post that bond and be released from custody, you would have written conditions of release. You may not return to the scene of any alleged crime, and you may not possess any weapons. All of this will be in your paperwork, ma'am. Did you have any questions?
What was the 25, what was the 25?
So because you failed to appear at a hearing, a warrant issued, and now in order to post bond, you have to post a total bond of $5,000.
Your Honor, I had called, because we had a family member that passed away, and I had called the court that day, and I don't know, they like mixed up everything on the court date. They end up, I left a message for the public defender, and I haven't heard from her yet. And then also, they end up just transferring me to probation. They transferred me to the lady from probation because I got released on probation. What they're going to do with the ankle monitor, they released me on the ankle monitor. And then when I was going to go pick it up, they just told me to just go to court. And then, we had all that family issue. We had somebody pass away in my family. And I had called the court to let them know. They're going to let the public defender know. And everything just got mixed up. So I don't know how that warrant came about.
So you failed to appear at your sentencing hearing for both of these charges. And although you may have contacted the court via phone, that's not the proper way to get a hearing continued. So if you still failed to appear at the hearing, it will result in a warrant, which is what happened in your case. So you'll need to ensure that you attend all of your future hearings. Your next one's November 25th at 8:30, okay? Please step to your left. The officer will get you that paperwork. Jeff to the podium, Edward to the chair. May I get your name and date of birth?
Jeff Scott Kukoff, 11/21/1969.
Thank you. You are here today on a new case. It is for 1 count of disorderly conduct and 2 counts of endangerment, both Class 1 misdemeanors. Probable cause has been found. I'm appointing an attorney to represent you. You're going to have an arraignment hearing November 25th at 1:30 p.m. in the Surprise Municipal Court. You do have a secured appearance bond in the amount of $2,500. In the event you post bond and are released from custody, you do have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. All of this will be in your paperwork. Did you have any questions, sir?
All right, so I have to post bond to be released?
Yes, sir.
Okay. I was not, okay.
Okay, if you'll step to your left, the officer will get you that paperwork. Edward Bosworth to the podium and Efren Contreras to the chair.
Morning, Judge.
May I get your name and date of birth?
Edward Bosworth, June 15th, 1964.
Thank you, sir. It does look like you are here on 2 cases. The first one is a probation violation warrant from the Superior Court with allegations that you violated terms 3, 4, and 5 of your probation.
What are those? Oh,
I'll give you an opportunity to speak in just a moment. I am going to appoint an attorney to represent you, and you're going to have a probation revocation hearing November 24th at 8:30. That's in the downtown Superior Courthouse. You also have a warrant from Peoria Municipal Court, and that is also for a probation violation. So I'll appoint an attorney. You'll have an arraignment hearing on November 25th at 9 a.m. That's in the Peoria Municipal Court.
Okay.
On the Peoria case, you have a secured appearance bond of $500. On your probation case with the Superior Court, it's $250. So that's a total bond of $750. In the event you were to post that bond and be released from custody, you would have written conditions of release. It does include not possessing weapons or alcohol and contacting your probation officer within 72 hours of release. All of that will be in your paperwork. Did you have any questions?
Yeah, I just wanted to tell you what happened. I've done years of probation without incident. What happened is I was assaulted in July and beat up, and I've got this traumatic brain injury I was diagnosed with at the Mayo Clinic, and I can't remember anything. It's the reason I forgot about probation. My daughter called me and said, "Hey, you got this in the felony warrant and stuff," and I can't remember things. I'm having problems. I've been in touch with my family, and they're deciding that I can't really take care of myself because I can't remember hardly anything. That was the issue, and I'm hoping that I can be let go, you know. If you would see, that's the difference. And my history shows that I haven't violated before. I have a traumatic brain injury, and I'm just having those kind of problems.
So although you may not have been contacting them, they've also attempted to reach you, and they've made field visits out to your home unsuccessfully, and you are on probation in 2 courts and are not satisfying the requirements of that, so you will need to post the bond in order to be released from custody.
Okay.
And if you do post that bond, make sure you go to those hearings, otherwise another warrant would issue and you forfeit the bond, okay?
Yeah, I can't go to something I don't remember, honestly.
Right, so it will be in your paperwork, so keep your paperwork on you, okay?
Okay,
If you'll step to your left, the officer will get that paperwork to you.
thank you. Is that bond something they can pay 10% on?
It is secured, so yes, sir, they can.
Thank you.
Efrain Contreras to the podium. Santos Bojorquez to the chair.
Good morning, Your Honor.
May I get your name and date of birth?
Efrain Contreras Garcia, May 28, 1996.
Thank you, sir. It does look like you are here on 3 cases. You have a new case and 2 probation cases. Your new case is for 1 count of dangerous drug possession, a Class 4 felony, 1 count of narcotic drug possession, a Class 4 felony. Probable cause has been found, and I'm appointing an attorney to represent you. Your other 2 cases are probation violation warrants that issued with allegations that you violated Term 6, 7, 11, 21, and 22. I'm going to appoint an attorney in those cases as well. You're going to have a probation revocation hearing November 24th at 8:30, a status conference November 25th at 8:30, and a preliminary hearing December 1st at 8:30. In each of your probation cases, you have a bond of $500. In your new charges, it's $250. That's a total bond of $1,250. In the event you were to post bond and be released from custody, you would have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 24 hours of release. All of that will be in your paperwork. Did you have any questions, sir?
I had a court on Friday. I don't know what happened to that court on the 21st at 8:30 p.m. a.m.
I'm not sure which case you're talking about, so I'm unsure what happened either. Did you have any questions regarding your release conditions?
Yes. Am I going to be able to get released or no?
You would have to post a bond of $1,250 to be released. If you're unable to post that bond, you will remain in custody and they will transport you to your hearings.
1,200?
1,250. If you'll step to your left, the officer will get you that paperwork. Santos to the podium, Danny to the chair. Can I get your name and date of birth?
Santos Carlos Bojorquez, 4589.
Thank you, sir. You are here today on a new case. It is for 1 count of burglary, a Class 4 felony, 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference November 25th at 8:30 and a preliminary hearing December 1st at 8:30. You do have a secured appearance bond in the amount of $500. In the event you were to post that bond and be released from custody, you would have written conditions of release. It does include not returning to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. All of that will be in your paperwork, sir. Did you have any questions?
No.
Please step to your left. The officer will get you that paperwork. Danny to the podium, Ricky to the chair. May I get your name and date of birth?
Daniel Ramirez, September 4th, 1999.
Thank you, sir. It does look like you are here on 2 cases. Your first one is a probation violation warrant with allegations you violated terms 3 and 5 of your probation. I'm appointing an attorney and setting a probation revocation hearing November 24th at 8:30. You have a secured appearance bond in that case of $250. You have a second case. This is a warrant from the Peoria Municipal Court. It has an offense date of October 17th, 2024 for 1 count of shoplifting, Class 1 misdemeanor, 1 count of failing to obey a police officer, a Class 1 misdemeanor, and 1 count of refusal to provide a true name, a Class 2 misdemeanor. I'm appointing an attorney in that case and setting a hearing in the Peoria Municipal Court on November 25th at 9 a.m. You also have a bond of $250 in that case. So between the 2 cases, it's a total bond of $500. In the event you were to post bond and be released from custody, you'd have written conditions of release. It does include not possessing any weapons or alcohol and contacting your probation officer within 72 hours of release. All of that will be in your paperwork. Did you have any questions?
No.
Please step to your left. The officer will get you that paperwork. Ricky Martinez to the podium and Michael Lopez to the chair.
Good morning, Your Honor.
May I get your name and date of birth?
Ricky Martinez,
September 10th of 84.
Thank you, sir. You are here today on a probation violation warrant with allegations you violated terms 12, 14, 19, and 21.
I have no idea what those terms are.
I'll go over those in just a minute.
Okay, thank you.
I am going to appoint an attorney to represent you, and you're going to have a probation revocation hearing November 24th at 8:30.
Okay.
In this case, you have a secured appearance bond in the amount of $500. In the event you were to post that bond, you have written conditions of release. It does include not possessing weapons or alcohol and contacting your probation officer within 72 hours. The allegations in the petition to revoke include term 12, which indicates you failed to submit to drug testing, and then it lists multiple dates. Term 14, it indicates you did not maintain employment. Number 19 is you had contact with a victim. Number 21 is a domestic violence violation that you did not comply with all the court orders as it relates to an order of protection. So those are the allegations in the petition to revoke. Your attorney can discuss that further with you and provide a copy, but that's the basic allegations they're alleging you have violated.
Understood.
Any questions?
I do. This is my first violation, so I just lost my house. I lost my whole family. I start work this Friday. I cannot afford a $500 bond. I would appreciate like a OR or a secured, like, you know what I mean? Like, I need to get out of here. I need to fix what's going on. Like I said, I start work. I'm on the right path. I stopped drinking last Thursday. I haven't drinking a drop since. I'm taking every step proper to better my life, minus the divorce. So I'm trying to do this on my own, and I cannot afford $500, but I need to get back on the grind for my own self and my life. That's all I'm asking. You know what I mean? I'll comply any other way. I don't understand how there's so many violations, because this is the first I've heard of anything. I've went to every way. I did lose my job, so I don't know if that was, you know, maintain. I was in contact with my probation officer every step of the way. I contacted him every day before 8 o'clock. So I don't understand how these violations came up. I do know that my ex filed a restraining order on me. She threw it out, and that's what this is all about. I have all the paperwork in my backpack. The cops have. All this order of protection is garbage. We got into an argument. She took off. The cops seen her, put her in a hotel. Basically, I don't want to say forced, but made her do a protection order. As soon as she figured out what was going on, she got it thrown out. I have court for that on the 20th to get it totally thrown out. And then I have I have a CT scan on the 21st for my liver. Like, I'm trying so hard to turn over a new leaf and become healthy. I graduated New Freedom when I first got out of prison last year.
I'm reviewing your probation notes while you're speaking, and it does not appear that the information listed in your probation notes agree with the information you're providing here today. It does indicate that there is an order of protection. It does indicate that the person protected on that may want that still to be in place. It further goes on to discuss the fact that you were not sober as of less than a week ago. I do have some concerns that the allegations list that you have violated no order contacts with the victim, so I am going to uphold the bond in this case. The bond will need to be posted in order to be released from custody.
This is the only way that I'll be able to survive. I don't mean to interrupt you, but like, I have zero contact with her. That order of protection, I have the paperwork. I have court on the 20th stating it's going to get thrown out. It's done, it's over with. I just need to get back to work, and I got to be there in 2 days.
As of today, and when the allegations of this violation, you had a valid order of protection, and what you're telling me is you still have one.
Correct.
I am going to uphold this $500 bond. Please step to your left and grab your paperwork. Michael Lopez to the podium, Timothy Sebastian to the chair. May I get your name and date of birth?
Michael Macias, 7/24/99.
Thank you, sir. You are here today on a failure to appear bench warrant that was issued related to a pending narcotic drug charge. I'll affirm the attorney previously appointed and set a status conference November 25th at 8:30. You have a secured appearance bond in the amount of $500. In the event you were to post that bond and be released from custody, you would have written conditions of release. Some things include not possessing any drugs without a valid prescription, not driving a motor vehicle without a valid driver's license, and then you'll need to ensure you attend the next hearing and all future hearings. If you were to fail to appear, another warrant would issue and you'd forfeit any bond you posted. All of that will be in your paperwork, sir. Did you have any questions?
Well, my last public defender said something about if I didn't go through with the diversion program, that my other option would be that I can get it down to a misdemeanor if I can get probation. And I'm not sure if that's an option that I can still take, or.
So you'll have to talk about that at your next hearing when your attorney is there, as well as the state. We don't have either of them here today. That would be a discussion between those two people, okay?
That's fine.
Thank you. Take a step to your left, the officer will get you that paperwork. Timothy Sebastian to the podium. Sean Summer to the chair.
Good morning, Your Honor.
May I get your name and date of birth?
Timothy Sebastian, March 16, 1988.
Thank you, sir. You are here today on 3 probation violation warrants with allegations you violated terms 3, 4, and 7 of your probation. I'll appoint an attorney and set a probation revocation hearing November 24th at 8:30. You have a secured appearance bond of $100 in each case for a total bond of $300. In the event you do post bond and are released from custody, you have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. All of that will be in your paperwork. Did you have any questions?
Well, if I'm getting going in, getting in jail or whatever, so how long will I be in?
So if you don't post your bond, you'll remain in custody until at least your next hearing on November 24th at 8:30, and you will discuss with your attorney and the judge at that time whether or not they're going to revoke your probation.
Okay.
Okay, if you'll step to your left, the officer will get you that paperwork.
Thank you.
Sean Summer to the podium. Talia to the chair. Can I get your name and date of birth?
Sean Summer, 4981.
Thank you, sir. You are here today on a probation violation warrant that was issued with allegations that you violated terms 4, 5, and 15 of your probation. Sorry, let me just look at something really quick. Okay. So you're here on a petition to revoke probation with allegations you violated terms 4, 5, and 15. I'm reviewing your case, and it looks like yesterday a petition to dismiss was filed, and it looks like it was granted on this case. So what I'm going to do is I'm going to appoint an attorney to represent you, and then I'm going to give you a hearing date. You're going to have a probation revocation hearing date November 24th at 8:30. But I am going to release you today on your own recognizance that you're promised to appear at that hearing.
Okay.
Make sure you contact your probation officer within 24 hours.
Yeah, absolutely.
Any questions?
No, ma'am.
Okay, please take a seat in the gallery. We'll bring you that paperwork. Can you reprint number 3? Talia to the podium. Can I get your name and date of birth?
Talia Jaramillo, 12/31/91.
Thank you, ma'am. It does look like you are here on a justice court warrant that was issued for failing to comply or failing to pay for a previous DUI.
Yes.
Due to the nature of your charges, you're not entitled to court-appointed counsel. I am going to set an arraignment hearing December 8th at 10:30 in the morning in the Agua Fria Justice Court. I'm going to release you today on your own recognizance. That is your promise to appear at that hearing. You will have written conditions of release. You may not possess drugs without a valid prescription, and you may not drive a motor vehicle without a valid driver's license. All of this will be in your paperwork, ma'am. Did you have any questions?
No, thank you.
Please take a step to your left. The officer will get you that paperwork. We're just waiting on the interpreter. Good morning. Do I have a Spanish interpreter on the line?
Yes. Aló, buen día.
Okay, we have one case. Are you ready to begin, ma'am?
Yes, I'm ready.
Good morning, sir. May I please get your name and date of birth?
Aló, buen día. Mi nombre es Dani y seré su intérprete en español. ¿Me puede dar, por favor, su nombre y su fecha de nacimiento?
Francisco Pérez Barajas, 10-17 del 54.
10-17 del 54, Francisco Pérez Barajas. My name is Francisco Pérez Barajas, 10-17-54.
Sí.
Thank you, sir. You are here today because a direct complaint was filed.
Está aquí el día de hoy porque el reclamo directo fue hecho.
It has an offense date of May 20th, 2022.
Tiene una fecha del 20 de mayo de 2022.
It is for 2 counts of aggravated DUI, a Class 4 felony.
Fue por DUI, por una falla.
I am appointing an attorney to represent you.
Estoy esperando un abogado para que lo represente.
You will have a hearing November 25th and December 1st at 8:30 in the morning.
November what, I'm sorry?
November 25th.
And December 1st?
December 1st, yes, ma'am.
Tiene audiencia el día 25 de noviembre y el día 1 de diciembre en la mañana.
You have a secured appearance bond in the amount of $500.
Y una fianza por $500.
In the event you post bond, you do have written conditions of release.
Y en el evento de que, que no quiera, tiene condiciones escritas.
It does include not driving a motor vehicle without a valid driver's license.
Incluye no manejar un vehículo sin una licencia de conducir válida.
All of this will be in your paperwork. Did you have any questions?
Todo esto estará en sus documentos. ¿Tiene algunas preguntas?
Sir, did you have any questions?
Señor, ¿tiene preguntas?
O sea que quería ver si me podía hablar más fuerte porque no oigo bien.
Oh, he wants me to speak louder because he doesn't hear me.
Okay.
¿Qué no escuchó, señor, de lo que le dije?
You're here for 2 counts of aggravated DUI, a Class 4 felony.
Está aquí por 2 DUI, por falla, por felony.
Está bien.
I am appointing an attorney to represent you.
Estoy asignando por dos crímenes, entonces estoy asignando a un abogado para que lo represente.
You have a hearing November 25th and December 1st at 8:30 in the morning.
Tiene audiencia el día 25 de noviembre y 1 de diciembre en la mañana.
¿Está bien?
You have a secured appearance bond in the amount of $500.
Y tiene una seguridad de correspondencia de $500.
In the event you post that bond, you have written conditions of release.
Y tiene eso, lo pone y tiene condiciones escritas para liberación.
You may not drive a motor vehicle without a valid driver's license.
No puede manejar un vehículo sin una licencia de conducir válida.
Did you have any questions?
¿Tiene alguna pregunta?
Oh, pues está bien, o sea, o sea, es todo lo que tengo aquí.
Okay. Oh no, it's good. It's good of what I have here.
If you will step to your left, the officer will get you that paperwork.
Si va hacia su izquierda, el oficial le va a dar esos documentos.
Está bien. Gracias. ¿Es todo?
Okay, it's fine. Thank you.
Gracias.
Is that all?
Yes, sir.
Sí, señor, es todo.
That does conclude our Spanish matter this morning. That's everything. I appreciate your assistance.
You're very welcome, and thank you for calling Lambert for your language needs. You have a nice Wednesday.
You too. Can I get your name and date of birth?
Yes. Corbett Eichenberg, on July 2nd, 2004.
Thank you, sir. And do I have the state on the line?
Yes, Your Honor. Ashley Stetson on behalf of the state.
Thank you, Ms. Stetson. I do note that we received a notice of appearance to represent the defendant in this case. The attorney's name is Tony Gonzalez. We did provide a link and information to appear here this morning, but we have not heard back from Mr. Gonzalez, and he has not appeared here this morning. So we are going to proceed in his absence. We are here today for a new case. It is for 4 counts of sexual exploitation of a minor, a Class 2 felony. Probable cause has been found, and I have noted in here that Mr. Gonzalez filed an entry of appearance. You're going to have a status conference November 25th at 8:30, a preliminary hearing December 1st at 8:30. Those are both going to take place in the downtown Superior Courthouse. Next, we're going to discuss your release conditions. Ms. Stetson, did you want to put your recommendation on the record?
Yes, Your Honor. Very quickly, the suspect is alleged to have had 4 images and/or videos of child sexual abuse material on a Kik account that was the account, Your Honor. The suspect did acknowledge that the Kik account, in regards to conditions of release or bond, the state is asking for $150,000 cash bond, standard conditions, along with conditions of no contact with minors, no use of internet except for work or school, and any other conditions Your Honor sees fit. Thank you.
Thank you, Ms. Stetson. Sir, I did review the allegations in this case, and I do have some concerns. I am setting a cash bond in the amount of $100,000. In the event you were to post that bond and be released from custody, you would be released to the supervision of pretrial services, and you would be equipped with electronic monitoring. You don't have written conditions of release. You may not have contact with minors, and you are prohibited from accessing the internet. All of this will be in your paperwork. Did you have any questions?
Am I going to get copies of when the court dates are?
Yes, when you step to your left here in just a moment, they're going to give you a copy of all of those things, okay?
Thank you.
All right, thank you, sir. This does conclude our 5 a.m. calendar. We will now stand in recess until 8 a.m. And Ms. Stetson, thank you for appearing here this morning.
Thank you, Your Honor.
I'm sorry? I know, I can't believe it.
Awesome. All right.
Thank you, guys.
violation warrant. So, on your new case, you were charged with 1 count of possession of drug paraphernalia of a dangerous drug, a Class 6 felony, and 1 count of criminal trespass, a Class 3 misdemeanor. I did find probable cause as to all 3 of the charges, and I did appoint an attorney to represent you. You do have a status conference hearing on November 25th at 8:30 and a preliminary hearing on December 1st at 8:30. I'm just going to pause for one moment. Okay. I just wanted to double check some information. You do have a secured appearance bond in the amount of $500. If you're able to post bond, you cannot return to the scene of the alleged crime, you cannot possess any weapons, and you must contact your probation officer within 72 hours of your release.
Yes.
Then as to your violation of probation, I appointed an attorney to represent you in that matter as well. You have a probation revocation possible disposition hearing on November 25th at 8:30. You do have a secured appearance bond in the amount of $250. Your total secured appearance bond between the 2 cases is $750. If you're able to post bond, you do need to appear for all of your court dates. Failure to do so, and also you have to comply with your release conditions. Failure to do so would result in the loss of any bond that you post. Warrants would issue for your arrest and additional bond could be imposed. So this takes care of everything that I needed to talk to you about today. If you have no questions for me, if you'll step to your left, officer will give you your paperwork.
Yes, sir.
Mr. McCoon, if you will please come to the podium, and Charles Hancock, if you'll please have a seat in the chair by the door. Hello, sir. Can you please state your first and last name and your date of birth?
Shonda McKeown, 0890.
You are here today because you have 1 new case and then you have 3 probation violations. On your new case, you were charged with 1 count of possession of drug paraphernalia, a Class 6 felony, and 1 count of criminal trespass in the 1st degree, a Class 1 misdemeanor. I did not find probable cause as to the possession of drug paraphernalia. I did find probable cause as to the trespass. I did appoint an attorney to represent you. You do have a status conference hearing on November 25th at 8:30 and a preliminary hearing on December 1st at 8:30. You have a secured appearance bond in the amount of $250 in this matter. Then as to your probation violation matters, I did appoint an attorney to represent you in all 3 matters. You do have a probation revocation potential disposition hearing on November 25th at 8:30. Each of those warrants has a secured appearance bond in the amount of $250. So your total secured appearance bond between all 4 of your cases would be $1,000. If you are able to post bond, you cannot return to the scene of the alleged crime, you cannot possess any weapons, and you must contact your probation officer. I do have to fix this order as well. You must contact your probation officer within 72 hours of your release. Failure to comply with your release conditions or failing to appear for your court dates would result in the loss of any bond that you post, and warrants would again issue for your arrest. This takes care of everything that I needed to talk to you about today. If you have no questions for me,
No.
if you'll go ahead and have a seat, we're going to bring your orders into you. I had to reprint the first one, the new case. And then I'm going to take a minute because it seems like my changes were not saved. So I'm going to double check the remaining orders so we don't have to keep. Mr. Hancock, will you please come to the podium? And Mr. Gill, if you'll please have a seat in the chair by the door. Morning, sir. Can you please state your first and last name? And
Yeah, my name is Charles Hancock, my date of birth 3/9/95. So say I had
You are here today on a new case. You were charged with 1 count of shoplifting or removal of goods, a Class 1 misdemeanor, 1 count of obstruction by refusing to give your true name, a Class 2 misdemeanor. I did find probable cause as to both of those charges. Due to the nature of the charges, you're not entitled to court-appointed counsel. You do have an arraignment hearing on December 9th at 9 a.m. I am inclined to release you on your own recognizance today, which means I'm releasing you today without bond. You do have to promise to appear for your court date. Do you promise to appear for your court date?
Yeah.
Okay, so you have the following release conditions. You cannot return to the scene of the alleged crime, and you must appear for your court date. Failure to do so would result in the warrant issuing for your arrest, and a bond will be imposed. This takes care of everything that I needed to talk to you about today. Looks like you might have some questions.
Okay, I was gonna say one thing, if I have stuff on my record that hasn't been removed yet, don't I have to say something about that?
You don't. I'm releasing you today.
Okay.
Mr. Gill. If you'll please go to the podium, and Mr. Maxwell Grantham, if you'll please have a seat in the chair. Sir, can you please state your first and last name and your date of birth?
Rajdeep Gill,
And what's your date of birth?
April 9, 1991.
You are here today because you have a warrant out of Tolleson Municipal Court. Due to the nature of the charge, you are not entitled to court-appointed counsel. Deputy, are we able to close the door just so that the defendant can hear inside? Thank you. You will have an arraignment hearing on December 8th at 8:30. I am inclined today to release you on your own recognizance, which means I will release you back into the community without bond. You do have to promise to appear for your court date. Ms. Sauer, we don't have a deputy inside of the court right now. Do you feel comfortable? No, this is not. We're still doing the warrants right now. Are you able to get out? Okay. I apologize for the disruptions. I am going to release you on your own recognizance today. That means I am releasing you back into the community without bond. You do have to promise to appear for your court date. Do you promise to appear for your court date? Yes? Okay. I'm letting you know right now that there was a recommendation that your bond be $500. So if you do not appear for your court date, this warrant will issue again, and you'll be looking at about $500 in bond. Failure to appear for your court date will result in this warrant issuing again, and that bond will likely be imposed. Do you understand?
Yes.
Okay, so if you have no questions for me, if you'll step, you have a question?
No, I don't have.
Okay, so if you'll go ahead and step to your left, the officer will give you your paperwork. Okay, we're gonna.
I think he's like messing with us where he says he doesn't speak English, but he's like talks to us, and then if he doesn't speak Spanish, he says something.
Okay. All right, Mr. Grantham, will you please come to the podium? Hello, can you please state your first and last name and your date of birth?
Maxwell John Grantham, 2/28/05.
Mr. Grantham, I just have some questions for you before we get started because I was unclear. It looks like you are here today because you have warrants out of Wickenburg, but it appears as though you were in custody. Are you going to be released from custody soon?
I was supposed to release last night.
Okay, so that's what I was just trying to confirm. So it seems like they did a warrants check before you release. We're going to take care of those, and then you'll be all set, okay? So you are here today because you have 2 warrants out of the city of Wickenburg. Due to the nature of the charges, you are not entitled to court-appointed counsel. You will have an arraignment hearing on December 3rd at 9 a.m. for both matters. I am going to release you on your own recognizance on both matters. You do have to promise to appear for your court date. Do you promise to appear?
Yes, ma'am.
You really do need to appear for your court dates because one of your warrants has a bond in the amount of $2,100, and the other warrant has a bond in the amount of $1,300. And I'm not clear as to exactly what was going on. It looks to me like when these warrants were issued, based on what I was trying to put together, is that you may have been in custody, and that's why these warrants were issued. So you do need to make sure you go to court. If you don't show up to court, these warrants will get issued again, and these bonds will likely be imposed. Do you understand?
Yeah.
Okay, that takes care of everything that I needed to talk to you about.
Is this in Wickenburg Court?
These are both Wickenburg courts.
So I would have to go to Wickenburg to
Yes.
handle it. It's hard. I haven't been back in a while. Thank you. Have a nice day.
Mr. Segura, will you please come to the podium? And I'd like to, before we call them the last 3, we need to clear.
We have 2 more. Or just enter the court. For all 3 of it. Your Honor?
Yes.
Okay.
Because I want it cleared before we do 22. Mr. Segura, will you please come to the podium?
All rise.
All right, thank you. Please be seated. Tiny calendars always feel so strange. Okay. This is the 11 a.m. initial appearance calendar for November 19th, 2025. Before we get started, I do want to read the victims' rights advisement in case there are any victims who are listening either here at the jail facility or online. And it goes as follows. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and the right to receive restitution from a person who is convicted of causing you loss. If you've not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the applicable prosecutor's office. All right, I think we do not have we do have an interpreter. I think I see that. Mr. Parra?
Good morning, Your Honor.
Good morning. Okay. All righty. Do you guys, you know what? I didn't know you were in court. Do you have, in fact, I was planning to actually email your division now that we are being asked to read that advisement on the top of the IA calendars, which is not statutorily required, but the court has asked us to do it, the leadership, sorry. I would assume, do you guys have a Spanish translation that you could just read now, or do you need me to go back through it phrase by phrase?
No, Your Honor, I actually have it in front of me. I can read it now.
Thank goodness. I thought, how in the world would you not have a Spanish translation of that? All right, yeah, please go ahead. Thank you.
Of course, thank you. Bien, esos son los derechos del ofendido en lo penal. Si usted es la víctima en una causa penal en el proceso ante este tribunal, por la presente se le informa que goza de determinados derechos con acorde a las leyes de Arizona, que incluyen, entre otros, el derecho al trato justo, respetuoso y con dignidad, el derecho a un proceso sin dilación, el derecho de hallarse presente en las diligencias sobre su caso ventiladas ante el tribunal, el derecho a decidir si permite que el inculpado o su abogado defensor lo entreviste a usted, el derecho a expresar su opinión ante la sala cuando el juez decida las cuestiones de la excarcelación del inculpado, la negociación de un convenio resolutorio, la programación de las diligencias judiciales y la imposición de la pena al inculpado y el derecho a la reparación por parte de la parte responsable de inferir los daños y perjuicios sufridos por usted y ocasionados por el delito. Si no ha recibido una guía escrita de los derechos del ofendido por el delito, sírvase a llamar la sección de servicios para víctimas y ofendidos de la Fiscalía.
All right. Good morning, sir. May I please have your full name and your date of birth?
Joander Rodríguez Guerrero.
Joandes Rodríguez Guedo.
What's your date of birth, sir?
Agosto 13 del 92.
August 13th of 92.
All right, sir, you have been arrested on one allegation of theft of a means of transportation. That's a Class 3 felony. Unlawful use of a means of transportation. That is a Class 5 felony. Obstruction of justice by the refusal to provide a true name, which is a Class 2 misdemeanor. There is probable cause for all of those things, and I am appointing a lawyer to represent you. Your next court date will be November 25th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be December 1st at 8:30 in the morning in the same court, and that address will be on your paperwork. Based on what has been alleged against you and your apparent ties to another state, Bail is set in your case at $5,000. It is secured bail. That means you can use the services of a bail bond company to possibly post bail for less than the full amount. You have other conditions of release, which will be in writing. Those include, you may not have any contact with the alleged victim of this crime, these crimes. You may not go to the scene of the alleged crimes. You may not possess any weapons nor any drugs without a valid prescription. You may not drive without a valid driver's license. And you may not leave the state of Arizona without the court's permission. It appears that you are a resident of Nevada. So I want to be very clear. You do not have permission at this time to leave the state. You need to go to your next court hearing, speak to your lawyer about requesting permission from the trial judge to leave the state. I am not giving you that permission today. Everything I've told you, your complete orders are in writing. If you please step to your left, the officer will give you your copy and you can give him the headphones. Thank you.
Okay, we're not done.
Okay, good afternoon.
All right, and really think that's our only person, but do you want to go ahead and make a general call just in case?
Of course, sir. Buenas tardes, soy el intérprete. Si se encuentra detenido y necesita asistencia en español en esta audiencia, levante su mano, por favor.
Okay, looks like we're good. All right, thank you so much. Have a great day.
Thank you, you too.
All right, is Mr. Woody in court? Jerron Woody? Yeah, why don't you come in real quick, sir? Let's get this printed up. Woody's printed up. Hi, Mr. Woody, go ahead and come to the podium. All right, will you give me your name and date of birth?
Jaron Woody, 12/25/1999.
Okay, thanks. Mr. Woody, I called you up first because I'm ordering that you be released immediately. According to the public access records we got, and I asked my court staff to call and confirm, you took care of this very case yesterday.
Yes, I did.
And should not have been arrested on this warrant. And so I don't know to what extent MCSO really cares in terms of timing, but I put twice on there that you're to be released immediately. I feel terrible for you that they towed your car. There's nothing I can do about that. I don't have any power to order DPS not to charge you with money for getting your car out. I put some notes in there saying you should not have been arrested on this warrant. So take my order to the, to DPS or to the impound lot, and you'll have to deal with them about saying that you should not owe them any money. I think that's terrible. There's nothing I can do about it other than to shout in my order, this warrant was taken care of yesterday. You pled guilty. You should not have been arrested on it. It just didn't clear out of the system fast enough. According to the Winslow court, they did everything on their end they were supposed to, and I think it was genuinely just a timing issue. And so DPS, they may be less than pleasant about trying to, do something for you on the tow fees. And all I can tell you is you can try. I don't have any power to order them not to charge you. You'll have to try to take that up with whatever ombudsman or liaison or, whatever department at DPS may deal with that. So I wish you good luck with that. I'm genuinely sorry that it happened. You'd think in 2025 it might have cleared out faster. But in any event, we've got it well confirmed, and I'll just ask Sheriff's Office, can you call somebody to come get him, please, anybody, and put him into the release queue? He should never have been booked in.
Yeah, I could call someone.
Okay, I really appreciate it.
Thank you, Your Honor.
Yeah, go ahead.
In my defense, I had my papers ready on spot.
You had them with you?
Yeah, I had them with me, and I showed them.
That's
I
terrible.
showed them. I showed
That's
the officer.
Terrible.
I was like, no, I just took care of this yesterday. I got my warrant. I took care of my
assumed you
warrant.
didn't have any proof, and you did, and they arrested you anyway.
Yes.
So I can't give you legal advice, sir, but somebody else could.
Okay.
And so what I would recommend is that you go get some legal advice about that at a free, maybe there's legal aid, maybe there's something, but,
Yeah, I even have it. I brought it over here with my stuff, and I told him, can you bring it into court whenever I go into court?
I'm honestly, frankly, sir, I'm appalled. And given the police agency, perhaps they would have been top of my list. If somebody told me that scenario, I would have said, was it DPS? More than that, I don't think it's appropriate for me to say. What I'm ordering is that you be released. And I wish you good luck in fighting with them about the tow charges or anything else that you may choose to do about this. But it is extremely clear that you should not have been booked in. And this was unjust. So I hope that MCSO, it's a little bit slow today. I hope they can get you out of here fast. It can normally take many hours. And I'm sorry, I only figured this out about 20 minutes ago. Or I would have actually personally asked them to start processing you immediately and not even bring you into court. So I'm just appalled. So please take your paperwork. Let's get you out of here and try to get you out that door as fast as we can, because that's deeply wrong.
I was even kind of like, no, I wasn't really arguing with the cop, but I was.
Right, you're trying to stand up for yourself and say, I literally am holding proof. Yeah. They could have, at a minimum, they could have waited for that court to open and called, but you know, anyway, I shouldn't say anymore. I only have your arrest in front of me. I noted it was not a valid warrant and you should have been released. So let's get you out of here with that.
So when we bring him out, I'm just going to close the door and talk to the officer, see if he's able to break that.
Tell him I'd really appreciate it. And you know, I mean, I was actually going to like maybe try to call Price or something and say, I know you guys take forever and nobody gets to jump the line, but I have never seen such a clear instance of somebody who shouldn't have been arrested. And I don't want to say more than that on the record, my opinion of what happened to Mr. Woody. So in any event, good luck, sir. If you take your paperwork, we'll get you out of here.
Thank you, Your Honor.
All right.
God bless
you. You too. Okay, thank you so much. Okay.
I'll be right back.
Okay.
So I talked to him.
Oh, great.
He's bringing him on down early to see what he can do.
Thank you so much. Which lieutenant was it, just so I know I can thank them?
I don't know.
You can't tell me.
It's one of the newer ones, and
I saw the insignia. Okay, that's great. Thank you. Yeah, that's just terrible. Alrighty. So anyhow, enough said on that subject. Mr. Salas, Dominic Salas, if you please come up. We're going to do the juvenile at the end, right?
Because they're taking care of it.
Oh, that's wonderful. That's great. Because now that guy has to get out and go deal with the fact that he has no car. Yeah. And they're going to charge him money to get it back. And the whole thing, I've said enough. All right. Mr. Salas, can I have your full name and date of birth?
Dominic Salas, 11/13/2000.
Okay, thanks. You are here on one new case and a probation warrant. In the new case, you were arrested Theft of a means of transportation, a Class 3 felony. Possession of a weapon by a prohibited person, which is a Class 4 felony. Driving on a suspended license, that's a Class 1 misdemeanor. And obstruction of justice by the refusal to provide a true name, that's a Class 2 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for you. Your next court date will be a status conference November 25th at 8:30 in the morning in the downtown Superior Court. And a preliminary hearing is scheduled for December 1st at 8:30 in the morning. Again, that's the new case. You're also here on a probation violation warrant. You're on probation for a Class 6 felony. Back on October 2nd, they filed a petition to revoke your probation. I don't know why it took them that long, since they allege that you absconded the day after you were reinstated last time. But that's when it went out. It was October. So I'm going to appoint a lawyer for you in probation court as well. Your next court date there will be November 25th at 8:30 in the morning. It's a revocation arraignment and possible disposition hearing. In the probation case, the court finds you will, in all reasonable probability, be revoked to prison. And so you do not have bail in the probation case. In the new case, the weapon and stolen car case, your bond is $25,000 secured with written conditions that, of course, include no victim contact. You shouldn't try to post that bond if you're still being held without bond in the probation case, because you wouldn't actually get out. You should end up with the same lawyer for both things. You can talk to your lawyer more about these cases next week. If step to your left, he'll give you your paperwork. Thank you. Mr. Hibbard? After that, Trey Vickers, we go to the chair. Hello, sir. Can I have your full name and your date of birth?
Jeremy Joseph Hibbard, 9/15/1980.
Okay, thank you. You are here on a warrant from the Pima County Superior Court, where you have been charged with theft of a means of transportation, a Class 3 felony. The alleged offense date in this case is back on October 30th of 2024. Looks like this warrant went out November 26th of 2024. I'm going to let them know they should give you a lawyer when you get there. Your next court date will be an arraignment hearing November 24th at 8:30 in the morning. That is this Monday, 5 days from now, in the Pima Superior Court, Pima County, down in Tucson. I'm affirming their bond. It is $2,500 secured. If you bond out, you need to be down there on Monday for your next court hearing, or you will lose that bail money, and they will issue another warrant for your arrest. Everything's on your paperwork, including a no victim contact order. If you step to your left, he'll give you a copy.
All right, thank you.
Mr. Vickers, Trey Vickers. And then Christy Cisco, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth?
Trey Vickers, 4/17/2000.
All right, thanks. You're here on a probation warrant. You are on felony probation, and back on November 3rd of this year, there was a warrant issued for your arrest alleging that you violated terms 3, 4, and 5. You'll get a copy of it from your lawyer. I am appointing a lawyer for you. Your next court date is a probation revocation arraignment hearing 1 week from today. When is Tuesday, actually? Yeah, it's Tuesday, the 25th, at 8:30 in the morning in the downtown probation court. Again, it's a revocation arraignment and possible disposition hearing. I'm affirming the probation judge's bond for you. It is $500 secured with written conditions. If you post it, comply with all of those and call your PO within 72 hours. This gentleman has your paperwork. Thank you. All right, Ms. Cisco. And then Ali Maliki, will you go to the chair? Hi, ma'am. Can I have your full name and your date of birth?
Christy Cisco, 3274.
Okay, thanks. You are here on a child support warrant issued out of the family court. This warrant was issued August 22nd of 2019. I'm going to give you a court date in the family court of December 4th. I'm going to count and make sure, is that 2 weeks? What's today? Hang on. I just want to make
December 4th.
Okay, today is the 19th. It just, whenever it's long, I like to make sure. That's not 10 days. In civil? All right. And
I don't think it matters in civil.
well, true. I mean, there's no speedy trial. All right. Yeah, I just don't like it. But I think it's the holiday. Yeah. All right. I bet. Okay. Okay, ma'am. What's that?
I'll double check it.
Okay, thanks. We're going to double check the date, but we're pretty sure it's right. And in a family court case, it's a civil warrant, and I don't believe you have the same rights as a criminal defendant. So what you have is a cash purge amount. Your court date is December 4th at 10 in the morning, which is 15 days from now. You have a cash purge of $500. It's not a bond, but you do have to pay it in order to get out. I don't know if you know this, but the way a cash purge works is if you pay it, you get out, and you still have to go to court, but you never get the money back. The court keeps it and puts it towards your child support debt. That's the difference between a bond you can get back, a cash purge you cannot. So I'm affirming the cash purge amount of $500. If you don't pay it, you are going to sit in the jail until December 4th, and you go talk to the family court judge about that. If you do pay it, you have to go on December 4th. I always really emphasize that because I'm told a lot of people show up in family court or later get warrants and say, well, I paid it. I thought I didn't have to go. You have to go regardless. Okay. So we'll let you know. I'm going to let you go out and take your paperwork, but my staff knows their business, so I believe that is the correct date. It's just unfortunate, and I think it's caused by the Thanksgiving holiday that it pushes out that far, but that is your situation.
Yes.
Except you left get the paperwork. Mr. Ali Maliki, and then Gina Mole, will you go to the chair? Good morning, sir. Can I have your full name and date of birth?
Ali Maliki, July 23rd, 2007.
Okay, thanks. You're here on two things. One is a new felony case. One is a misdemeanor warrant. In the new case, you were arrested for possession of narcotic drugs for sale. That's a Class 2 felony. Also, possession of drug paraphernalia, a Class 6 felony. Paraphernalia.
What is that?
It means things used to ingest, sell, otherwise contain illegal drugs. You can talk to your lawyer about it. It could just be a baggie. Like in your case, there was at least one baggie. So talk to your lawyer about it. It's a lesser offense, definitely, than the Class 2 felony. But so talk to your lawyer. I am appointing a lawyer for you. Your court dates will be in 2 weeks. The first one is a status conference, December 4th, 8:30 in the morning. That's in 2 weeks. And a preliminary hearing, December 8th at 8:30. The court address is in downtown Phoenix, and it is on your paperwork. Now, reviewing your case, it appears you are barely 18. We did not find any juvenile or criminal history for you beyond the traffic warrant that you're also here for. And yet you are in front of the court on an allegation that can carry some extremely severe penalties. But that being said, I don't believe on balance, reading it, that what's alleged against you indicates that you're not smart enough to fly right and show up for court and not commit new crimes while the case is pending, and that once you realize, what you could be facing on a bad outcome versus what you might face on a good outcome, I think you're probably likely to comply, and I'm willing to give you a chance on these facts. It's not fentanyl. It's not methamphetamine. And what you're alleged to have done is incredibly stupid, which I think you'll find out when you talk to your lawyer, that making money selling vape cartridges is a terrible, stupid way to make money. And it can land you in some extremely hot water. But police say you were very cooperative with them, meaning I guess just what I said, you don't appear to have any other history. So I'm willing to give you a try at pretrial services and not make you post a bond. It doesn't appear that you were making an enormous profit from this if you did it, which is just an allegation right now. You're presumed innocent. And that you aren't the sort of like hardened drug dealer or something that the court might put a bond on straight out of the gate. But I don't want you, Mr. Maliki, to fail to take this seriously. A Class 2 felony, there's only one class of felony higher than a Class 2, and that's a Class 1. There's only one way to commit a Class 1 felony, and that's murder. So it goes murder, selling hard drugs, and vape cartridges are narcotic drugs under Arizona law. It's not weed. It's a hard drug. So you don't need to say anything because you're getting the very best. I'm just trying to explain to you because I worry people in your position, youngsters, will think, whew, this is a bit of a wrist slap. Oh no, sir, you have a bad problem. I'm just making a bet that if I let you out, you'll come to court, you won't commit new crimes. You'll just do what we tell you and show up and get some advice from your lawyer. That's all I decide. I don't even decide whether you did it. They appear to have a strong case against you, which means most lawyers will tell you you should try to look like a good candidate for a probation offer. Now, you can fight the case. You can go all the way to trial and you know, try to make the state prove their case. That's your right. You don't have to agree, take a plea or anything like that. But the county attorney has a lot of leverage on somebody in a case like this, a lot of leverage. They could offer you probation. And somebody as young as you, with no real criminal history, you are likely a good candidate for probation. I don't know, that's not up to me. But what I'm trying to do is impress upon you that you can't pick up any new charges while the case is pending. You cannot miss any court dates. That I want you to understand why I'm doing it, because I don't see anything in here other than what you're accused of to suggest that you're not smart enough to go, I'm going to go to court. I'm going to talk to my lawyer, and I'm not going to get in trouble while this is going on. Because, you know, the punishment for a Class 2 felony can absolutely include prison. Mm. And so, get a job.
Of course, yeah.
Go bring proof to your lawyer that if you look like a good kid, that can only help you. Don't think that you skated and this is a wrist slapping. If you are picked up on any felony while this case is pending, which could be just possession of one vape cartridge that you are using yourself, you will end up held without bond. And I'm not going to walk you through why, because you won't remember it anyway. I'm just trying to say, like, wow, I just hope that you're not the kind of kid who goes, woohoo, like, that was easy, I got my first name. Like, no, you have a bad problem, and it's not going away just because I release you. You're just going to make it far worse if you don't show up. Do you understand?
Yeah.
Okay, and I gave you a lawyer. Go talk to your lawyer in 2 weeks. In the meantime, be good. All right, now you're here on a Peoria warrant for not showing up on a fictitious license plate ticket, which doesn't tend to indicate you like to go to court. But a Class 2 felony is a whole world of different than a Class 2 misdemeanor. Do not fail to appear. You're going to get a bond. And on drug sales, it's probably going to be at least $5,000.
Yes, sir.
So go to Peoria City Court. Your lawyer in the felony case is going to go, don't pick up any warrants while this is going on. Show up for all of your court dates everywhere. So go to Peoria. I'm going to release you on your own recognizance. I can't make you report to pretrial for a misdemeanor. So it's December 9th at 9 in the morning up in the Peoria City Court. It's on your paperwork. If you don't show up in Peoria, you're going to catch a warrant, you're going to get a bond, and you're going to make your problem worse in the felony case. Your whole focus right now should be on that felony case. Get the best outcome you can, okay? All right, everything is on your paperwork. Call into pretrial services when you get out. We're going to give you an envelope. Just do what they tell you. It's not hard. Follow your orders and come to court, okay?
Just one question. Does that mean I'm getting released today?
Yes.
Okay, thank you.
But you're getting released on a pretty serious charge, which is why you're getting a lecture. It's very specific to your case. It isn't something that I normally do.
Thank you so much.
You could ask the DOs. I'm probably one of the harsher people who do this job in terms of release conditions. But what you're specifically accused of doing, I don't think means you're likely to screw up on pretrial.
Thank you, Your Honor.
Screw up means miss a court date, violate release conditions, pick up a new charge. That would be screwing up. Okay. If you step to your left, you get your paperwork.
Thank you so much, Your Honor.
All right, Ms. Mole? And then did Mr. Griffin come in? Okay, you'll be next, sir. Okay, right here, ma'am.
We have the Sheriff Griffin guy here now.
The what?
The guy that has Phoenix Court, Sheriff Griffin, he's here now.
Oh, yeah, thank you. Right, yeah, he's next. Okay. Ma'am, can I have your full name and your date of birth?
Gina Elizabeth Mole, 12482.
Okay, thanks. You're here on a new case. You got booked in for many things that I'll read for you in a moment. The one that I found probable cause for purposes of today's hearing only is driving on a suspended license. It's a Class 1 misdemeanor. They booked you in for aggravated DUI as a Class 4 felony, possession of drug paraphernalia, a Class 6 felony, and 2 allegations of misdemeanor DUI. What they failed to establish sufficiently for probable cause was the impairment And it's my belief, by the way, they're going to wait for blood results. That doesn't really factor into my decision. They didn't establish whether you were or weren't under the influence. If I was betting the person, I would bet that you were. It doesn't matter, though. I'm releasing you. But I'm going to just give you a court date and just caution you and order you not to drive. You lack the legal right to drive. Also, people who do this kill other people with their cars. And so I don't love releasing people who I think are repetitive drunk drivers, because they are eventually going to kill themselves or others, and it seems to me like it's always somebody else. That being said, right now the police did not get over the mark with probable cause for you, so all I've got is a misdemeanor. I'm not going to even give you a bond on the driving. I'll suspend it. That's my legal obligation. I still think you're dangerous. So go to court. Talk to your lawyer. It's up to the county attorney whether they file it now, wait for blood results, whatever it is that they're going to do. So I put a number in your paperwork. You can call that number a few days before your hearing, which you're hearing the 4th. So maybe on the 1st, call the number and say, do I still have a court date on the 4th? Because if the county attorney decides to wait for the blood results, they're going to scratch your case, and you don't have to show up. That's the purpose of the phone number. And then they can send the misdemeanor to a justice court. So anyhow, I'm giving everyone too much information today. I'm releasing you on your own recognizance because I only found probable cause for the misdemeanor. But those DUI allegations are not dismissed. I don't dismiss charges. I just set release conditions. So you're still ordered not to drive. I have the power to do that, and you utterly lack the legal authority to do it, and I sincerely believe you will eventually kill someone or yourself if you keep doing it, because I get to do those cases and sign the warrants for the blood draws all day long. So don't drive. You're not allowed.
Yes, ma'am.
Everything's on your paperwork. If you step to the left, you get a copy.
Thank you.
All right, Mr. Griffin. And then are we going to clear before the juvie? I don't care. Because he's already in adult custody. Right here, sir.
So what I'm going to do is, while you work on the house call, I'm just going to go drop these off, go grab the juvie for you.
Good plan. Okay, thank you. All right, sir, can I have your full name and date of birth, please?
Sherrod Latif Griffin, 1192.
Okay, thank you. Mr. Griffin, you're on a new case. You got booked in for aggravated DUI, a Class 4 felony, reckless driving, a Class 2 felony, and failure to show a driver's license or ID when driving. That's a Class 2 misdemeanor. There is probable cause for all of those. I am appointing a lawyer for you. Now, I'm going to give you your court dates in a minute. I have to remember those. And I was going to save you for last anyway because I wanted to talk to you. Your case is very much on the bubble for me. On the one hand, you've got priors. You have a history of alcohol offenses. They have strong probable cause against you. Reading this, I believe you...
Ma'am.
Sorry, I'm going to talk, okay? And then I'll let you know what I want to know from you. So, normally, someone like you, with these allegations in your criminal history, bang, $5,000 bond, we're not even talking about it. Because what you're accused of doing makes other people dead. It absolutely does, and I don't care. I mean, I know that. That is the job that I do. I read about it all the time. But you aren't actually accused of hurting anybody. And you apparently successfully completed probation or got early termination for sufficient compliance last year, which also indicates you can comply with court orders. You can do what the court tells you to do when you're under the court order. So that would tend to indicate perhaps I could release you with an alcohol testing order and a very strict and all caps order not to drive, because you don't have the right to ever be behind the wheel of a car at this time in Arizona. But then pretrial said they terminated the interview because you were being uncooperative and belligerent, and they almost never type notes like that. So I don't know what went down with pretrial. So I wanted to get my own feeling for whether I think you might comply with pretrial and what you would have to say about, can you get yourself to work? How are you going to avoid driving? How are you going to give me some assurance that I'm not releasing a repetitive drunk driver out to kill somebody?
Ma'am, I promise. I don't drive. This is a step back. I haven't been behind the wheel like that, ma'am. I promise. My friend just got into a situation. He got shot in the back of his head. I was kind of going through a little situation, ma'am. I swear to God, I got 3 kids at home.
And
I'm the only.
Like you have a job.
I'm the only one that works as of right now. I work for behavioral health, ma'am, as I got caught in my scrubs. I'm doing my best, ma'am. I just had one little.
Well, could be one large, but, all right, this is what I'm going to do, Mr. Griffin. I don't want you to lose your job, but I don't want you to drive, and I don't want you to drink.
I won't, ma'am.
So I'm going to send you to pretrial with a strict alcohol testing order. You're going to have to test for us. But I won't make you post a bond. And I was ready to do it, to give you a bond, until I saw that you completed probation last year, which tends to indicate you'll comply with my orders. I don't know.
I complete every time, ma'am. Every time I have it.
Which counts for something. Now, so I'm gonna order that, okay? I'm gonna release you. You have to call in after you get out, and they'll set up the alcohol testing. But you probably already know, because you took the endangerment DUI combo plea last time. They're not going to give you that again. The county attorney is real strict about that. You only get that once. Do you remember the mandatory minimum for the Class 4 DUI from last time you went through this? Do you remember it? Well, I want to tell you, and the reason is, I hope that it helps you fly right while you're out, because you are presumed innocent. You enjoy the presumption of innocence. But I think anybody who knows the potential downside, that it makes them, I hope, if they're a consequence-oriented person, they which many people aren't, that it would make them more frightened into complying. And it is 4 months in prison. No judge can give you less. If you are convicted in this case, regardless of whether I let you out, no judge can give you less than 120 days in the state penitentiary. That can be, if you're coming to court, you're doing what you say, that can be timed, to a more convenient time, yes. But eventually you have to go do 120 days. That is extremely serious. It's my understanding, you have to talk to your defense attorney, and they talk to the prosecutor. If you pick up an ag DUI while this case is pending, they're going to start their offer at 2.5 years. So if you just get another ag, you know what I'm saying? So the hammer is large over your head, even right now. And I hope that's enough to get you to comply. And the idea of, I don't want to be away from my kids any longer than I have to, and I want to get the best outcome that I can. And it's because, and everybody in here, except the new person, has heard me give the spiel to DUI defendants so many times. Because we sign the statewide blood draw warrants out of this building. Statewide, all we do is sign blood draw warrants. And DUI makes people die. It makes utterly innocent people die. It is a terrible crime. I didn't know that until I worked here. So I'm always reluctant to let repetitive drunk drivers out, really reluctant. But you've got other things that I hope will motivate you to comply. And that's mainly your children and your job. And like I said, it does mean a lot to me that you were sufficiently compliant with probation to earn early termination last year. And that counts for something. So I hope you don't prove me wrong. Come to court. Go alcohol test for us. Talk to your lawyer about outcomes in your case. That's what they're there for. And don't drive. Okay?
Yes, ma'am.
All right. Any questions for me?
No, thank you.
All right, well, good luck, sir. If you step out to your left, you can take one. All right, I'm going to do the house call record. Let me ask you the question real quick before you go out. As to Michael Cisneros, Eric James, and Victor Mota, are they not physically present in court because they've been isolated by the sheriff's office as potential risks of danger to themselves or others?
Yes, Your Honor.
Okay, all right, then I'm going to do those house call records right now while you do your traffic business, and we'll reconvene for Angel Rodriguez. Okay, thank you. All right, so I will go see Mr. Cisneros, born 3/17 of 68, in-house to conduct his initial defense. I'll advise him he got arrested for 4 things. For purposes of this hearing, I only found probable cause on 2, but not the others. The 2 that I did find probable cause are criminal trespass in the first degree of a yard, which is a Class 1 misdemeanor, and indecent exposure to an adult, which is a Class 1 misdemeanor. The ones I did not find probable cause for are the dangerous drug possession, Class 4 felony, and drug paraphernalia, Class 6 felony, because the police didn't provide enough information to support the allegation that what he had was methamphetamine. So I will let him know that and appoint a lawyer for him, and I'm intending to give him a court date of November 25, and then I didn't give Griffin his court dates, because that's classic for me. He has them in writing, but anybody listening, Mr. Griffin's court dates will be December 4 at 8:30, that's a status conference, and preliminary hearing December 8. All right, back to Mr. Cisneros. His court dates will be a status conference November 25 at 8:30 and a preliminary hearing December 1st at 8:30 in the downtown Superior Court. And it's my current inclination to set bail for Mr. Cisneros on those misdemeanor at $1,000 secured. It would have been higher had I found probable cause for the felonies, and that's based on his criminal history and the specific facts alleged against him. The court is worried about the alleged behavior and the potential risk to the community and the alleged victims. I plan to order him not to return to the scene of the alleged crimes, no contact with those alleged victims, no weapons, no drugs without a valid prescription. Mr. Eric James, born 3/26/94, is here on a new case. He got booked in for criminal trespass in the first degree. He was booked in as a Class 6 felony, but on these facts, it can only be the Class 5 felony, criminal trespass of a critical public service facility. So I made a note of that in my order. I do find probable cause for that Class 5 felony. I am appointing a lawyer for Mr. James and planning to give him court dates of December 4th at 8:30 for a status conference, December 8th at 8:30 for a preliminary hearing. And I'm hopeful that Mr. James appears when I speak to him to be okay to release to pretrial services supervision. That would be my inclination as pretrial services. I will order him not to return to the scene of the alleged crime. I will ask him, does he have any reason to go to the airport between now and early December? And assuming he does not, I'm just going to leave it as he can not return to the scene of the alleged crime. No contact with the arresting officer, etc. All right, Victor Manuel Mota, born 10/19/91, is here on a warrant from the state of Texas. And I believe Mr. Mota is on a suicide watch. And so I will inform him that it is a probation warrant from Texas. And it was issued September 24th of 2025. And he is on felony probation there for aggravated assault. So I'm going to give him a court date in the extradition court of December 1st at 1:30 in the afternoon. We will provide him with a copy of his fugitive rights in this case, and I do have to order him held without bond because this is a post-conviction warrant. So he's going to be held without bond, and his next court date is December 1st at 1:30. All right, if anything changes after I go conduct these house calls, I will put my final decision in my written order. I don't plan to update the recording unless I find a need. And we're just going to take a little pause while we wait for Mr. Rodriguez to be brought back into the courtroom. So let's go ahead and go off the record if we could. Big red dot, okay. All right, sir, hello. I need to advise you of two important rights that you have because you weren't in court when the recording played, and that is you have the right to remain silent in a criminal case about what you've been accused of, and you have the right to the assistance of a lawyer, and I am going to appoint a lawyer for you in this case. All right, can you please give me your full name and date of birth?
Yeah, Angel Santos Rodriguez, 11/27/2008.
Okay, thanks. Mr. Rodriguez, you are in court today because there's been a grand jury indictment handed down against you 2 days ago, and it alleges that on July 21st of 2025, you committed aggravated assault on a correctional officer, which is a Class 5 felony. So an indictment means the grand jury met, they heard evidence, and they found probable cause to formally charge you with that crime. So I'm going to appoint a lawyer for you. You should end up with the same lawyer for all of your cases. So if you have already met that person, this should go right to them. If not, they'll have everything. And you'll get a copy of the charges from your lawyer and police reports. So your arraignment hearing is going to be November 26th, which is 1 week from today, Wednesday the 26th, 8:30 in the morning. I am affirming the grand jury bond in your case, the one the judge set out of grand jury. That is $50,000 secured. That's on top of any other bonds that you have. You have written release conditions in this case as well. No victim contact, no weapons, no drugs, no alcohol. It's probably very consistent with what you had. And because you're under 18, I do need to make a housing order. I've considered the factors in the Federal Juvenile Justice Delinquency Prevention Act, and I am going to order that you just stay in MCSO custody. I know you're already there, so my order is that you just stay. Okay, so this will just get put together with your other cases. Eventually, all of your hearings will come together, and you won't have so many trips to court. I'm not able to do that today. All right. Okay? All right, we're going to get you a copy of the paperwork. If you step to your left, this gentleman has that for you. Okay, thank you. All right, then we are going to, anybody looking for house call records? I did them prior to Mr. Rodriguez's case, and so they'll be on the recording about 5 minutes ago, 3 minutes ago, I don't know. All right, but we're going to stand in recess now until 2 p.m. this afternoon. Okay, we're in recess.
Reprint of that, okay? Yeah. Okay, I'll grab it. I'm gonna go drop them off and then
I'll meet you right there, okay.
And that completes it, all right. This other, if you go over here and just turn I complete, it doesn't pull up any police orders. Okay. Oh, yeah. The only one that I have now is the FOJ, because they won't get both copies of the receipt. You can give them a second. Here's your release report.
I'll come back for that in a bit. I gotta go drop them off.